Hi, folks. I'm Greg McLawsen, the Affidavit of Support lawyer. I represent I-864 plaintiffs in federal lawsuits to enforce the affidavit, and I serve as a consulting expert in family law cases when green card holders are enforcing the Affidavit of Support in the context of divorce proceedings. So we're talking about basics today. How do you sue an Affidavit of Support sponsor? So first of all, who has a right to sue an Affidavit of Support sponsor? Well, it's a beneficiary, an immigrant for whom an I-864 was executed. This happens in all family-sponsored immigration cases. Usually when we're talking about Affidavit of Support enforcement, we're talking about a spouse suing a former spouse. That's usually when it comes up, although these Affidavits of Support are assigned in all family-sponsored immigration matters. When it comes to a lawsuit, the Affidavit of Support beneficiary can recover damages that are equal to the difference between their income and 125% of the federal poverty guideline. That's roughly $1,400 per month under 2022 levels. So a beneficiary, the green card holder, has the right to go into state or federal court and recover breach of contract damages that are equal to the difference between their income and 125% of the federal poverty guideline. But how do you do this if you are a beneficiary? Well, you don't need a lawyer. In the US system, anybody can represent themselves in a state or federal court proceeding, and that's no different here. In fact, I always say this, I've never seen it happen, but you could potentially even enforce the Affidavit of Support in a small claims court. Depending on your jurisdiction, the amount that can be sought in a small claims court action is limited, but it's usually in the neighborhood of $10,000 or so. And often the amount that's in dispute in Affidavit of Support claims is pretty small. So you could potentially go into small claims court. You're going to surprise a judge there because they will have never seen this before. But at the end of the day, this is a contract. But, let's talk about courts generally. When it comes to any civil legal claim, so that's a financial claim in this case, it is customary, though not required, to start with a demand letter. So when I represent a green card holder in an Affidavit of Support lawsuit, our first step is always to send a demand letter to the other side. This outlines the nature of the claim, explains the law on the issue, and explains what it is that our client is seeking to recover. Now, the regulations governing the Affidavit of Support are very clear that an immigrant doesn't have to do this. So you can certainly go directly to court without sending a demand letter. And there are circumstances in which that's appropriate to do. So for example, if we've had previous litigation between the parties, we know that they're not just going to respond amicably to a demand letter. Sometimes it does make sense not to waste time going back and forth in a case where we know, or we're pretty confident, they're just going to say, forget it, sue us if you think you're entitled to money. But typically, it's a better use of both parties' time to at least make an effort before you go running into court to see if you can work out a settlement agreement. Most legal claims, sooner or later, do result in settlement, and that's a good thing for both parties. If you have to fight a case all the way through the legal system, in a real sense, that's a failure, because that's all of those resources that are going into the litigation process could have been spent coming to an amicable resolution. And in the case of a sponsor, that money could be spent on a settlement instead of paying lawyers on both sides of the equation to litigate a claim. So most cases, you are best off, before you think about going into federal court or state court to enforce an affidavit, send a demand letter to the other side and explain what it is that you're entitled to. The math isn't hard on this, right? The damages that you're entitled to as the green card holder are, again, the difference between your income and 125% of the poverty guideline. So if you can figure out your income, you know what it is that you're entitled to under the affidavit. So that's just arithmetic, and that should be a pretty compelling case to the other side. It's typically not a factual issue as to whether the other side has executed the affidavit, right? If you have green card status through a marriage, there's really no question about how you got it. If you have an IR1 status on your green card, that tells you right there that you got your green card through a family member, and it's pretty obvious it's the spouse. So really, there's very little effort in these cases that's expended arguing over whether or not residency status was achieved, and we're not arguing over whether the affidavit of support was executed. Typically, to the extent there's any factual dispute in these cases, it tends to be around what the income of the sponsored immigrant has been, because again, that's the determinant for what damages are. So let's say that you're doing this yourself, you've sent out the demand letter and nothing happens. You can try again, you can try sending a second demand letter. Sometimes you can get somebody to wake up the second time. But if somebody on the other side, if the sponsor truly is non-responsive, then the only option you have to compel them to comply with their affidavit of support obligation is to sue. That's what the legal system is for. When people and they can't be compelled to comply with it, you and have a judge tell them to do it. Court cases, whether we're talking in state or federal court, begin with something called a complaint. A complaint sets forth your allegations about why you as the plaintiff is somebody initiating a lawsuit, why you as the plaintiff are entitled to relief. A complaint for the affidavit of support, ours, the one we typically use, is about 13 pages or so, but at its most basic, it doesn't have to be that nuanced. The basic facts that are alleged in the complaint are that the petitioner/sponsor brought the immigrant into the country, and in the process of doing so, signed an affidavit of support. Now, you as the immigrant may not have that affidavit of support because this is a document that's typically prepared and signed by the sponsor, often without the intending immigrant having a chance to look at it. That's fine. First of all, an immigration attorney could serve as an expert in your case and tell the judge that the affidavit of support had to have been executed because the immigration agency wouldn't have the legal authority to grant status unless this affidavit had been executed. But aside from that, you can also get a copy of your affidavit of support along with the rest of your immigration file by filing what's called a Freedom of Information Act. That's free to do, Freedom of Information Act request. The form is the G639. You can get it free from the USCIS website. You can file the FOIA request, as people refer to it, free on the USCIS website. That's very easy to find with a Google search. Those come back in typically 1 to 2 months. Processing times go up and down, but that's a really easy way, and again, it's free, for you to get a copy of your affidavit of support. We do this in all of the cases we file because we want to have that full immigration history that shows without any question that the US-based family member signed the visa petition, which is the I-130 or the I-129F. We want to show that they signed the affidavit of support and have all of the documentation about how our client got status. But you can certainly proceed into the initial stages of the lawsuit before you've completed that FOIA request, because again, it does take 1 to 2 months to get your results back, and it makes sense not to delay the progression of your lawsuit while you're waiting to get this contract that you know was signed. You know it was signed because you couldn't, as the immigrant, have secured status unless the document was in your immigration file. So complaint, if you want a copy to see a draft to see what one of these affidavit of support complaints looks like, contact us on our website. This is not secret, it's publicly available information. We're happy to give you a copy of the complaint that we use when we sue affidavit of support sponsors. And it should be pretty easy to alter that complaint based on the facts of your situation. So complaint is drafted, and then a lawsuit is initiated with serving the complaint, which is that factual and legal allegation about why you're entitled to relief, plus a summons. A summons notifies the defendant that yes, they are being sued, and tells them how long they have to reply to the lawsuit. Under the federal rules of civil procedure, that's 21 days after they're served individually. So this is where you hire a process server that has to go out and find the defendant individually and serve them with the documents to notify them that the lawsuit has been initiated. Where does the lawsuit go from here? Well, so this is where the paths diverge in terms of what to expect in affidavit of support lawsuits. The majority of cases, not all, but the majority of cases tend to get resolved relatively early on. So once the lawsuit has been served and the sponsor understands that, yes, you are really serious about asserting your claims under the affidavit, that tends to be when the sponsor lawyers up, gets some legal advice, and realizes that this is a real thing. They have serious financial exposure, and they're willing to come back to the bargaining table if they haven't already been able to do that and talk about what a fair resolution of the case is. So roughly speaking, 50% or so of cases get resolved after the complaint is filed and before really serious time has been spent on the litigation process, and a lot of time has been spent in court. But not all of them. So of the remaining cases, some significant legal work is done on them in the court context before a resolution is reached. Oftentimes, that time will be spent with defenses that are raised by a sponsor. So a sponsor will raise what are called affirmative defenses, which is to say, look, I don't dispute that I signed the affidavit, but I am arguing nonetheless that I am not liable for this reason. So the most common one is fraud. They argue that they're not liable because they were duped into marriage, the marriage was never real, and they allegedly were married only for the purpose of a green card. Courts have nearly unanimously rejected that defense in the context of the affidavit of support, saying that it's not supported by the federal statute that underlies the affidavit. And that goes for all defenses related to contract formation. So courts in the Seventh Circuit Court of Appeals, Washington Federal Court, courts in California, the 11th Circuit Court of Appeals have all said that none of these contract-based defenses apply in affidavit of support lawsuits because it's governed by the Immigration and Nationality Act and not general rules of contract law. But for whatever reason, some sponsors and some sponsors' lawyers will not acquiesce to that well-established case law, and they'll still try to argue defenses that ultimately fail. So you've got to get into a court battle with them about whether these defenses can stand, and eventually they will get knocked out, at which point the case can progress towards settlement. Even after that happens, some sponsors want to go into the discovery process. So they will want to invest resources in poking around at whether the plaintiff has undeclared income. So a lot of sponsors will get it into their head that the plaintiff, even though they're living perhaps in a women's shelter, has undeclared income and is secretly earning lots and lots of money. Well, they're entitled to do that if they want to do that, and if they want to spend the resources on it. You can use discovery to get at any relevant information or any information that might lead to relevant information. So this is a very broad entitlement to information gathering. And some sponsors will spend significant financial resources, trying to rake through all of the details pertaining to the plaintiff's income. This tends to be foolish because if you look at the actual amount that's at issue in these lawsuits, we're talking about $1,400 per month. So to invest tens of thousands of dollars to figure out if the plaintiff's income is $0 or $300 a month just doesn't make a lot of sense. But you can't force anybody to be reasonable, and some sponsors do want to spend a lot of time going through every possible notion of where the plaintiff might have money. After discovery is complete in these lawsuits is when the parties can move for what's called summary judgment. That is a pre-trial attempt to show the judge that there's no issue that deserves moving to trial. Now, if the sponsor has put up complete resistance to the lawsuit, just proved totally unwilling to come to the bargaining table, the summary judgment stage is typically where this thing will ultimately get resolved. Because that's the point at which the plaintiff will be able to say to the judge, look, there's just no factual question about what my income is. The defense might have whatever crazy ideas they want to have, but when it comes to the actual evidence, here's what my income has been. And when you can present that to the judge, that's typically going to resolve the case, that there's not going to be an issue that's worth impaneling a federal jury over to determine what this person's income has been. So in almost all cases, if the case hasn't already been settled, it will get to the summary judgment stage, and that's where the judge will say, sponsor, this is what's owed under the contract, end of the case. In very, very rare cases, you will have the matter proceed all the way to trial, potentially on that issue of, well, what was the actual income of the plaintiff? We've seen this in a case where the plaintiff and the defendant had a business together. So maybe there's a question about what income needs to be attributed to the plaintiff. It is very, very unusual, especially in federal court, to see these matters progress all the way to a jury trial, because again, there just isn't a factual issue that merits fact-finding by a jury. At the end of the day, it's typically well established by documentary evidence what the plaintiff's income is, and when you know that, you know what's owed under the contract. So that's kind of the overall distribution of how these cases resolve. Some of them get resolved at that initial pre-litigation demand stage, when the plaintiff sends out a demand to the defense, notifies them of their claim, and the parties are able to come together, talk resolution. That is the best result for both parties. The sponsor spends less on the case, and the plaintiff gets a faster resolution. That's the best case scenario. The next big chunk of cases get resolved not pre-litigation, but early in the litigation process. So after the complaint is filed, the lawsuit is initiated. Once the sponsor has an opportunity to lawyer up and get good legal advice, then the claim settles before the parties end up spending a bunch of money on litigation. And then you have the rest of the cases, which is the minority, but there are some that proceed significantly into the litigation process. Again, sometimes this involves knocking out affirmative defenses that are raised by the sponsor, despite all of that case law that says affirmative defenses don't apply. And then some cases get into extensive discovery over the plaintiff's income and might even, a very small percentage, make it to trial on that issue down the line. But again, bottom line is that most of these cases are going to result in settlement sooner or later, and both parties are best served if that can be as early in the process as possible, when the legal costs are as minimum as possible. If you have any general questions about suing under the Affidavit of Support, feel free to drop them in the comments. I'm happy to respond there. If you would like individualized help, contact us on the website. We're happy to set up a video consultation anywhere in the United States. Good luck. Hope this is helpful, and take care, everyone.